Good afternoon, everyone, and welcome to the Fall 2019 Honors Lecture Series on Suffrage. My name is Dr. Philip Phillips, and I'm the Associate Dean of the Honors College. And I am coordinating this lecture series in partnership with Dr. Mary Evans, who is a Research Associate Professor of History and one of our honors resident faculty members. She's also the head of the American Democracy Project on our campus. We have a very impressive lineup of speakers. We are going to cover a lot of important issues. One of the things that inspired this series was the fact that we are now leading up to the 100th anniversary of the ratification of the 19th Amendment, giving women the right to vote in this country. And so that's an important milestone, it's an important event. And the topic of suffrage as well, we're looking at it from multiple perspectives. We're very excited about the speakers we have. So at this time, I would like to invite Dr. Evans to come up and to introduce today's speaker.
We celebrate suffrage this semester, focusing on women's suffrage with the upcoming centennial of the 19th Amendment, but we are dedicated to learning about all aspects of suffrage, the vote, the franchise. Dr. Sekou Franklin is with us today to speak about the African American right to vote, theoretically secured by the 15th Amendment in 1870. And that was almost 150 years ago right now. His talk is titled 15th Amendment, it's been shortened here, but African American suffrage and the ongoing struggle for voter justice. Dr. Franklin is an associate professor in the Department of Political Science and International Relations at MTSU and is the coordinator of the Urban Studies minor here at this university. He's a preeminent national scholar. He is the national president of the National Conference of Black Political Scientists, an esteemed honor. He's the author of After the Rebellion, Black Youth, Social Movement Activism, and the Post-Civil Rights Generation, published by New York University Press in 2014, and he edited The State of Blacks in Middle Tennessee. He was appointed to the Tennessee Advisory Committee for the U.S. Commission on Civil Rights in 2016, and in November of 2016, he coordinated the Tennessee Election Protection Hotline in collaboration with the Lawyers Committee for Civil Rights. He serves on the coordinating committee of Democracy Nashville, Democratic Communities. So if all of that I just said is only so many words, please note what's relevant for us here today. Dr. Franklin has worked on many voting rights cases, and including one right now. The Tennessee State Conference of the NAACP, the Tennessee Equity Alliance, the Andrew Goodman Foundation, look him up if you haven't heard the name, and Democracy Nashville Democratic Communities, that's Dr. Franklin. They're the plaintiffs. They're suing the Tennessee Secretary of State, Secretary Trey Hargett, the Administrator of Elections, the Tennessee Attorney General, and the State Election Commission, who are the defendants, in U.S. District Court, Middle District of Tennessee. They are suing the state because the Tennessee General Assembly passed a law this past spring. Now, Tennessee State Law, Public Chapter 250, I handed out a copy of that to you actually on the very first day of class. Have you read it yet? It criminalizes voter registration in the name of voter security. Never mind the Russians, we want to be sure our own American citizens are penalized. For my own American history class today, I was rereading the words of 19th century populist Mary Lease, who observed that the politics of the late 1800s had become so bought, she said, by the wealthy that they've sold out the heartbeat of humanity. Democracy itself has been corrupted, she said. The will of the people, the consent of the governed have been subverted. And if the governed can't even get registered to vote because state laws are purging the voter rolls and access to registration is limited for them by their circumstance, that happened many times in history and it's happening again today. In the late 1800s, after gaining the right to vote, racist states removed tens of thousands of black voters from the voting rolls through legal maneuvers, not dissimilar to what's going on in Tennessee today. Dr. Franklin has a new book coming out in just a couple of months, co-authored with Ray Block, on race and Tennessee politics through the University of Georgia Press, titled Losing Power African Americans and racial polarization in Tennessee politics, about how modern Tennessee has emerged as a more racially and politically divided state than ever in its history. Again, his title for the book is Losing Power. Please pay close attention to Dr. Franklin's talk today. Take many notes, if you will, so that you'll be prepared to ask our Tennessee General Assembly members who will be on this stage just 2 weeks from today good, thoughtful, careful questions about your citizenship rights. Dr. Franklin's lecture and the panel at Tucker 1 week from today, and the women's panel at Tucker on Tuesday, 9/17 at 2:30. I trust you've made your plans to be sure that you will be there. Will be your final primers before you have the opportunity to speak directly to our legislators who'll be visiting with us. University Honors College is very, very pleased to welcome back Dr. Sekou Franklin. Thank you.
Okay, and I want to thank Dr. Evans for inviting me to Honors College, Dr. Phillips. I see Dr. John Vile there. We call him a political science nomad, but he's probably doing more work than any of us in the department who are line professors, so I want to acknowledge Dean Vile there as well. And this topic of voting rights and the 15th Amendment and African-American voter justice is a topic that is very dear to me. I've been working on voting rights disputes for about 9 or 10 years. Accidentally, that is. I got into it by a mentor of mine from Williams College who came out of a very well-known civil rights organization called the Southern Regional Council. And he kind of linked me into a broad network of folks working on voting rights. And since then, since 2009 to 2010, I've gone through some training on voting rights and redistricting, have worked with groups such as the Southern Coalition for Social Justice, which is based out of Raleigh-Durham, working on with the group right now, the NACB LDF, Legal Defense Fund, looking at judicial districts in Tennessee, and I have worked also with the Lawyers Committee for Civil Rights and a couple other groups. So this topic is dear to me, and I also teach a voting rights course. I've taught a voting rights course on 3 occasions, and for that course, I've taken students to the Alabama Black Belt, primarily Selma, Alabama, and Lowndes County, and on one occasion even to the Carter Center to talk about election protection and voting rights internationally. So this is a topic that's dear to me, and I thank you for inviting me. The first thing I want to do is just define what this term voter justice is from my perspective, a working definition. And some of my previous experiences working on voting rights issues, and this presentation is going to draw from both some of my personal experiences, some of my research looking in archives, gubernatorial archives, as well as archives at the National Archives in Washington, D.C. and in Maryland, and again, my personal experiences. But some of that work convinced me that the way that we understand civic and political engagement, broadly speaking, that is, needs some adjustments. And what voter justice does, it expands our understanding of civic advocacy and democratic participation by arguing for at least a more innovative approach to voting rights. And the idea is that we need to look at voting rights and voting rights and tactics used to advance civic participation as being anchored in grassroots movements and indigenous organizations. And this idea, this notion of voter justice expands beyond traditional electoral practices and essentially is arguing that we need a more current, aggressive, grassroots anchored project or movement focusing on voting rights. So what this idea of voter justice does is that it accounts for the historical residues of centuries-long patterns of exclusion from voting, systemic and dilutionary barriers to voting, and I'll talk some more about this later on in this presentation. It argues that we need to look at free and fair access to the voting booth without barriers, either intended or unintended. Voter justice also speaks to this idea of having no monetary costs that discourage full participation. It looks at racial priming, often excluded from our discussions. Racial priming is based on the idea that codes, dog whistling, can be subtext of campaigns, and those codes, racial codes, those schemes, that dog whistling can be used to actually discourage voting. And then it argues for more innovative practices and approaches to advancing civic participation and voter participation, which I'll talk about later on in this presentation, what I call parallel institutionalism, relying upon intersectional allies, looking at grassroots election-oriented election protection initiatives. And then I urge, I don't talk about this much in this presentation, but we need to look at some of the impacts that larger social and political changes have on voter participation. Natural disasters, if you look at Hurricane Katrina, my mother lives in Panama City, half the town was wiped out by Hurricane Michael. If you look at foreclosure and the subprime mortgage crisis, all of that's impacting voter participation. If you look at something like high incarceration rates, there's a lot of research that shows how that actually downsizes voter participation. So voter justice tries to move beyond our traditional kind of interpretation of voting rights and looks at it much more holistically, much more broadly speaking. And some of this presentation gets to that issue. But just kind of a short summary of the 15th Amendment, ratified in 1870. And I do want to emphasize the point that a small number of African Americans were able to vote prior to the Civil War. In fact, in the 1840s, with the emergence of kind of anti-slavery parties, we saw some African Americans even running for vice president on anti-slavery parties like Frederick Douglass, for example. And there was a small percentage of African Americans who were able to vote, who were free, maybe in the North, and in some cases, maybe 100 or so, maybe in parts of the South prior to that period of time. But the 15th Amendment removed restrictions to the vote based upon race, color, and previous condition of slavery. In a nutshell, it gave African American men the right to vote. It did not give or extend that right to vote to women, at least universally speaking, and this caused a lot of tension, which I think will probably be discussed later on. It caused a lot of tension between the women's suffrage movement and the abolitionist movement, particularly those African Americans pushing for the right to vote. There's a lot I can say about that, perhaps in the Q&A. But what the 15th Amendment did was it allowed for African Americans, for a lot of different reasons that are complicated, to serve in Congress. 16 African Americans served in Congress during Reconstruction in the 1870s, 1880s, on up to 1901, in which the last person left Congress. 600 plus African Americans served in state legislatures during this period of time of Reconstruction, principally because of the 15th Amendment, and 11 of whom served in the Tennessee state legislature beginning, I believe, in the late 1870s, early 1880s. But there were some challenges to the 15th Amendment. Again, it did not include explicit references to gender or sex. That means that women were not covered by the 15th Amendment, and this caused a major split between the abolitionists and women's suffrage movement. Number two, it did not include an explicit reference to Native Americans. So Native American voting rights was stalled literally for decades. And it was kind of built into electioneering practices at a state-by-state level in a really kind of more troubling, problematic way in American political history. And of course, it was open to federal court challenges, which ultimately, as you'll see a little bit later on, the federal courts came in and reversed or retrenched the 15th Amendment. But really, the 15th Amendment worked as part of an umbrella of federal statutes, federal laws, agencies getting involved in voting rights cases. The 14th Amendment, for example, preceded the 15th Amendment. That eliminated the 3-5 compromise. It made African Americans, it gave African American citizenship. If you see right there on the left-hand side, this is a really important set of pieces of legislation. They call these enforcement acts or the Ku Klux Klan acts. These were two laws that essentially joined at the hip that created federal penalties for mobs, Ku Klux Klan-like organizations that attacked African Americans in the voting booth. It was a robust intervention strategy by the federal government. And then in the South, in at least 5 states, federal troops were placed in the states that actually protected African American voters. Tennessee was the exception. Tennessee did not have federal troops there. And then something that's not talked about, but I think we should talk about it more, is that the U.S. Justice Department was formalized in 1870. Now, prior to that period of time, there was a U.S. attorney, there were other agencies, but what the Justice Department did in the 1870s was it brought those moving parts together at the federal level and essentially created an entire department. And one of the first things that they did, as you'll see right here, is that they took the enforcement acts, or the Ku Klux Klan acts, and they enforced it in a robust way. I got this from the National Archives 2 years ago, and this right here is the Justice Department appointed a special prosecutor in the Northern District of Mississippi to enforce the enforcement acts. And these names on the side right here, and I got a bunch of them that are in my files, are people who essentially were attacking African Americans at the voting booth. And the Justice Department was bringing real cases under the Enforcement Acts and under the 15th Amendment in a way that really we don't see today. So this period of time of Reconstruction was so important in terms of giving African Americans the right to vote, African American men the right to vote, that is, expanding voter protections, and really getting African Americans elected to office. But the Reconstruction came to an end, and so did the 15th Amendment, at least the more robust enforcements of the 15th Amendment. Restrictions were placed on African American voters in the mid-1870s, and it lasted on up to the late 1890s. So African American voting behavior and voter turnout began to decrease because of the retrenchment of voting rights and the end of Reconstruction. The Hayes-Tilden Compromise was a compromise between Reconstruction-era Republicans, what's called radical Republicans, and also Southern Democrats. That turned the South, what we call the South, back over to the hands of the former Confederates. Federal troops were removed, and as a consequence of that, Reconstruction civil rights era policies essentially came to an end. You had voter intimidation that took place. One of the more damaging cases that came out of the Supreme Court in 1896 was a Cruikshank case. And this case revolved around the Colfax massacre in Louisiana, in which African Americans were essentially massacred as they were trying to push for the right to vote. And the Supreme Court came in, and essentially, it's more complicated than what I'm describing, but had the effect of invalidating the Enforcement Acts. So that meant that African Americans could no longer receive the protections under the Enforcement Acts, the Ku Klux Klan Acts, when the violence was being carried out by private or state militias or private groups. The Supreme Court came in with a series of policies in the 1880s and 1890s. Some states passed laws prohibiting African Americans from voting or placing severe restrictions on the African American vote. And it varied depending upon the state. Some states passed laws placing restrictions on African American voting in state constitutions. These were probably the most severe laws that were passed in places like Mississippi and South Carolina. And along with that, you had literacy tests, later changed the understanding tests in some states that mandated that African Americans had to pass a test that in order to vote, and they would have to answer questions such as, how many bubbles on a bar of soap, how many beans and jelly beans are in this jar. The grandfather clause was also part of this post-Reconstruction era set of policies that mandated that in order to be eligible to vote, your grandfather had to be eligible to vote, and most African Americans at that time in the late 1800s were essentially enslaved persons in the South. Poll taxes were implemented, and you also had all-white primaries, and at that time in the one-party South, the Democratic Party South, essentially banned African Americans from voting. And so what you had by the late 1880s was a reversal, was a retrenchment. That is, that African Americans, it's probably the only time in American political history in which a group was able to experience noticeable voter turnout, noticeable explicit victories in elections, and then all of a sudden they wake up and African Americans could no longer vote. There are no African Americans being elected to office. In the case of Tennessee, as an example, the last African American left office, and I want to say the late 1880s, and no African American was elected to the Tennessee state legislature until 1964. And Tennessee is considered to be, by some, for different reasons, a more moderate state compared to other deep southern states like Mississippi and South Carolina. So you had an overall retrenchment, and these laws are ultimately reversed and eliminated, these kind of restrictions laws, but it took some time. And as you can see right here, this is a kind of a table of, it's kind of a fun table that looks at what occurred in black counties, that is majority black counties that had a literacy test versus majority black counties that did not have a literacy test. And you can see that the voter disparity is like 35%. The voter registration disparity is like 35.7% in the early stage of post-Reconstruction era politics. And you can go down the line and find that in the early stages, pre-1900, the literacy test had a dramatic impact on those black counties that had a literacy test compared to those that did not have a literacy test. This is another kind of diagram of Louisiana, and you can find this a similar kind of diagram, or similar kind of results in other states, in which you find that the voter registration rate in Louisiana near the end, by 1900, it was low by 1900, but you saw a dramatic dip in the years following. So we could find data point after data point after data point showing that basically what the post-Reconstruction era brought was essentially a reversal in which African Americans were not able to vote in many parts of the South. And often the deep southern states that had the most African Americans were the states that essentially had the most severe levels of intimidation and the most severe levels, the most severe forms of restriction. Some refer to that as what's called racial threat thesis. That is, in those areas where African Americans were significant majorities, you saw the most severe forms of restriction and the most severe levels of violence enacted against African Americans. But there was resistance to this. There was resistance. And we know of what's called the post-World War II civil rights movement, but the resistance preceded that period of time. We saw a number of African American groups organizing resistance campaigns to expand voting rights. We saw the emergence of civic and voter leagues, which is deserving of a book project. African Americans developed civic and voter leagues designed in part to pay for poll taxes. And Tennessee was one of the innovators of that process. We saw citizenship schools being developed in the late 1950s and early 1960s, designed to educate African Americans how to pass literacy tests, right? How to register to vote, how to engage in civic education. We saw, and they even in some cases targeted citizenship schools by the congressional district. We saw voter clinics being developed as well by groups like the Southern Christian Leadership Conference and Martin Luther King Jr. and SNCC and groups like that. We saw individuals organizing, even before the World War II, things like Abolish Poll Tax Week, mobilizing African Americans to raise their resources to pay for the poll tax or to push the lawmakers to abolish the poll tax. And we saw state poll tax repeals, interestingly enough, in places like Alabama before Tennessee. So we saw grassroots organizations and alliances being developed essentially to push back against severe voter restrictions, and ultimately what you found was significant change. This is an example of a poll tax in Tennessee based on some of my research and looking into the archives. You can see that in 1913, for local elections, you had to pay $1, and that amounts to about $25.92 today. $2 amounts to about $51 today for poll taxes. And so for a poll tax, what you would have to do is you would have to pay by election. And if you were from a dual household, a dual traditional household, the husband and the wife would both pay poll taxes. So interestingly enough, it's one of the important things that the poll tax saw, and the elimination of the poll tax in Tennessee specifically, saw an alliance emerge between civil rights groups, between women's rights groups, and between radical labor organizations, right? Who said, we have to stop this poll tax. And they forced the governor, Prentice Cooper at the time, to repeal the poll tax. In fact, there's an interesting story in which Prentice Cooper asked the governor of Alabama to send him their poll tax repeal process. Because the reason why women wanted the poll tax repeal, because in a traditional two-parent household, in a state that is, for the most part, poor, what happens if you have to pay a poll tax from a dual-parent household? Well, the husband pays a poll tax, but the woman, the wife, they don't pay her poll tax. So there's these interesting letters in which all these individuals or groups are writing Prentice Cooper saying, repeal the poll tax. The Tennessee Supreme Court overturned the poll tax repeal. And the 3-2 decision, in a case, I got to give it to Dr. Weil, in a case to this day I still can't understand. I don't understand what it means, I don't understand the outcome, but that's kind of what you saw in terms of the poll tax in Tennessee. So another interesting movement that occurred in Tennessee that pushed for voting rights was the Tent City campaign, primarily in Fayette and Haywood counties. In the late 1950s, there was a big dispute over a jury trial. And African Americans in rural West Tennessee, in places like Fayette and Haywood County, for the most part, they had major restrictions placed on their ability to vote compared to African Americans in Nashville and Memphis. And they thought that someone was being convicted, an African American who was wrongfully convicted. So they then pushed for a campaign for voting rights. And as part of that campaign, African Americans, for the most part, experienced a community-wide reprisal. It's one of the few voting rights movements of that period of time in which there was a massive reprisal against the entire community. What are some examples? The sharecroppers were kicked off their land and forced to live in tents. What's another example? Many African American women were barred from using the hospital. So there's examples in which African Americans had to go to Memphis to give birth. African Americans were denied food at the local store. They were denied gas. So there was a massive regional community mobilization exercise that occurred from different parts of the South designed to bring in emergency relief to the tent city campaign of that time. And it's one of the major kind of voting rights movements that that was grassroots led. It wasn't led by SNCC or by Martin Luther King Jr. It was totally generated by local and indigenous people. And that campaign of 1959 through 1962, the tent city campaign, was significantly important. Why? Because here's the thing, the flagship legislation for voting rights, the Holy Grail, one of the top 5 or 10 domestic policy achievements in the United States, was the Voting Rights Act of 1965. Okay. Prior to that time, Congress and the President, Eisenhower and Lyndon Johnson, who was a minority leader in the Senate at the time, essentially, a Republican and a Democrat, got through the 57 Civil Rights Act and the 60 Civil Rights Act. Now, in layperson's terms, the 57 Civil Rights Act and the 60 Civil Rights Act are seen as watered down laws, as insignificant. They didn't do much. They created the Civil Rights Division in the Justice Department, but they didn't really do much. However, what those two laws did collectively was they allowed for intervention in the Tennessee tent city campaign, right? A Justice Department attorney came into Tennessee and brought 2 cases, I believe one for Fayette and one for Haywood. And it's one of the few examples in which those 2 laws saw enforcement. And Tennessee is really ground zero for essentially enforcing both the 57 and 60 Civil Rights Act. But the Voting Rights Act, as I stated earlier, was a flagship piece of legislation. It's the kind of the holy grail of civil rights advocacy efforts. And it's a pretty lengthy law, but the 2 most important parts of that law for the purposes of this class, of this session, is that it created what's called Section 2. Section 2 outlawed discriminatory practices, whether it be moving polling places, violent intimidation, and other kinds of discriminatory practices, broadly defined. Again, African-American activists and civil rights groups wanted a broad interpretation of that, right? People who were more conservative wanted a more narrow interpretation. And it created what's called Sections 4 and 5. Sections 4 and 5 were what's called trigger and pre-clearance provisions. And it said that if you lived in a state that had a higher level of voter intimidation, a lower level of voter turnout, then that state, if there was any changes made to an election law or procedure, that election law had to be pre-cleared or approved by the federal government, usually the Justice Department or a federal court like the U.S. District Court. The reason why that was important was because as the Voting Rights Act was getting underway, a lot of states were just going to change the laws. We're just going to change the rules of the game. And so what the Sections 4 and 5 did was it said, you know what, if you change the rules of the game and prohibit African Americans from voting, the Justice Department has to look in to see if it's going to prohibit African Americans from voting. And so these 2 provisions of the Voting Rights Act were significantly important in expanding African Americans' ability to vote. In 1970, the Voting Rights Act was extended again, to young people ages 18 through 20, with the approval of the 26th Amendment being ratified. In 1975, it was extended again to, in this case, to non-English speakers, Chinese Americans in New York City and Chinatown. Native Americans, for the first time, received the most robust coverage that they had because many Native Americans spoke their nation's language, their tribal language, as their first language. Latinos who spoke Spanish as a first language. So it extended voting protections for those groups in addition to reinforcing, reauthorizing previous provisions. And then it was extended again in 1982, dealing primarily with redistricting efforts, and then again extended again in 2006. Those are more complicated kind of components of that. But then something happened in 2013. In 2013, the Supreme Court issued a case called Shelby v. Holder. And Shelby v. Holder essentially gutted the Voting Rights Act. It was probably the most significant defeat that the Voting Rights Act faced in the many court challenges that it had since '65. And this is what Shelby v. Holder did. Shelby County, not Shelby County, Tennessee, by the way. Shelby County, Alabama, which is right outside of Birmingham. And what it did essentially was eliminated Sections 4 and 5. Eliminated pre-clearance provisions. And the attorneys who brought the case shopped the case around. They looked for a district or a county in which is vulnerable that could ultimately make its way to the Supreme Court. In reality, pre-clearance needed to be updated, and there's been bipartisan laws proposed, bipartisan bills to update pre-clearance. But even still, eliminating the pre-clearance provision, what it did was it opened up the faucet for a wave of voter suppression tactics that emerged after 2013 in a series of states, primarily in the South, that really kind of hurt our struggle for voting rights. So in the 1970s, I want to point this out. In the 1970s, I want to emphasize that when the Voting Rights Act was passed, there was something known as what Frank Parker calls a white backlash. So what happened after the 1970s was civil rights activists and voting rights activists had to go to the federal courts to protect the Voting Rights Act. In part because what you found in parts of the South in particular was that many state legislatures, right, and authorizing bodies began to change the laws challenging the pre-clearance provision. And in many cases, the pre-clearance provision held up. But one of the things they did was essentially to create what's called face-neutral or race-neutral strategies and tactics and electioneering practices that had the effect or consequence of diluting the black vote, even if explicitly it didn't say it. So I'll give you one example out of many. In many places in the South, particularly Mississippi, which Frank Parker writes about, if you're going to be a superintendent of a school, you were elected. You were elected. But if you're in a place like Greenwood, Mississippi, or Macomb, Mississippi, and that might have been 80% African American, but only 2% African Americans are registered, and which basically meant you had to be a college professor or a funeral homeowner, right? Then all those superintendents, all those council members were white. Now, with the Voting Rights Act being passed, that county that was 80% black now is going to elect what? A superintendent who's African American and a council members who are African American. What the state legislature would come in and was they would change how that process occurred from an election to an appointment. And the appointment would happen just before African Americans got the right to vote. So there are all these kind of face-neutral or race-neutral practices being implemented just at the point in which African Americans got the right to vote. And so the civil rights activists had to go to the federal courts and fight against what's called voter dilutionary tactics, which on the surface were face-neutral, but in reality were designed to hurt African Americans. In terms of contemporary problems with voting, I'm going to go through this quickly. The struggle for voting rights is present. It's now. It's here. It's not a relic. It's not a thing of the past. It's right now. There are a number of contemporary problems taking place, and I'll just describe a few of them. There's still the issue of legal fines and fees that people who are formerly incarcerated have to pay in order to get their rights restored. I'll spend more time on some of these issues in a couple of minutes. There's a reduction of early voting days. We've seen examples of voting precincts being removed, voter purge laws, photo identification laws, unfair redistricting practices. We see cases in which prisons are located in districts in which people in that particular area are able to count those members for the purposes of apportionment and redistricting, and that's called the usual residency rule. We see other issues around redistricting that are important, and I'm kind of going through this quickly, but I'll focus on a few examples. The photo ID law is an example. Here in Tennessee, we updated or revised or implemented rather a new photo identification law, and this has been a subject of a lot of debate. It's not entirely simplistic. It's not entirely. It's more complicated than what people have typically talked about. Let me see if I can summarize this. In the mid-2000s, there was a push for photo identification laws, a bipartisan push, in fact. Coming out of the Carter Center. It was called the Carter-Baker Commission. But it was designed to create uniform practices across the country in the aftermath of the Florida election of 2000. But instead, the commission released a report on photo identification laws that excluded what was called the minority reports by voting rights activists. And voting rights activists argued that, look, if you push for voter identification laws, states they'll be given a rope and they'll go much further than what you expect them to do. And that's what happened. So fast forward, particularly after the Obama's election, a lot of states passed new photo identification laws mandating that in order to vote, you have to pay for a government-issued ID, and it varies across the country, right? And so some of the data that we found is that 11% of voting-age citizens did not have a government-issued ID. 18% of seniors in some cases African Americans, low-income residents. The South, people are 3 times more likely not to have a photo identification law than the non-South. 32 states implemented voter identification requirements. The federal courts struck down voter identification laws in Texas and North Carolina as going too far, but upheld it in most of the other states. The Pennsylvania Supreme Court also struck down the voter identification law, but that was a state Supreme Court. And this is the Pennsylvania case that was pretty egregious, in which literally you needed documentary proof of citizenship, a social security card, and proof of address. And the case was brought by Applewhite versus Commonwealth of Pennsylvania. And had it went through, a lot of people would have been excluded from voting in the case of Pennsylvania. Here in Tennessee, when the voter identification law was implemented, the Brenner Center did a study along with the General Accounting Office of what impact would it have on Tennessee. And they found that the 900,000 plus voting age citizens live 10 miles or more from the nearest voter identification issue location. A number of individuals don't have a vehicle, so they're not able to obtain a voter identification law. There are 3 rural areas that have a lot of individuals who do not live near a photo identification issuing area. And the General Accounting Office found that the photo identification law would reduce turnout among African Americans by 3.7%. That's a low number, it seems, but it's not. And if in a presidential election, 3.7% amounts to tens of thousands of people. We've also seen a problem with vote caging. Vote caging basically allows political operatives to register with an election commission and show up at an election precinct or voting precinct and challenge voters who they presume or interpret as being illegally involved in voting. And the way it happens is that political operatives can send a first-class letter to people who they've identified from the voter rolls as ineligible voters or unresponsive voters. And if the letters are returned unopened, the individuals are placed on a caging list. And there are different ways to do this. Operatives then show up at the election precincts to challenge these voters. And they can challenge voters. They're supposed to just not challenge voters directly, but they're supposed to essentially tell the election precinct workers that this person may be ineligible to vote. And even if it doesn't work, just delaying the time between voters being able to vote can significantly hurt or harm the vote. It's been used against African Americans, Latinos, and HBCU students at places like, I believe, Prairie View A&M had an issue with this being used against them. Vote purging is the issue. A number of states have purged laws that remove voters from the polls. I worked on this issue a little bit. This is a woman from East Nashville who's purged from the votes, purged from the rolls. Voters may live at non-traditional residences, so they oftentimes are purged. States will hire companies to determine eligible voters for purging. And so you find voters who may be on the voter registration rolls as John L. Smith, but somehow they're identified as John Smith. You find voters whose names, my father's name is Thomas Franklin, which might be a common name in some parts of the country. So there could be 3 or 4 voters who have that similar name. So those kinds of inconsistencies could be used as a purging device to purge voters from the rolls. And in Tennessee, we've had a major purging issue, in part targeting people who are considered to be, quote unquote, infrequent voters. That is, voters who typically have not voted in the last 2 November elections. And I think some people have worked on trying to improve this in the last, I think League of Women Voters has been on the front lines trying to work on resolving that issue. And this is an example of a purging list from Rutherford County. I pulled this list about 3 or 4 years ago. And you can see this is typically what a purging list looks like from the Election Commission. There could be legitimate reasons for purging. Someone died, for example, but like a death, but there could also be issues of inactivity in which a lot of voters who may not vote in the presidential or congressional elections may be purged from the voter rolls. I've worked in the election protection system before and found some voters who have been purged from the rolls who didn't know it, but they just didn't vote in the last 2 or 3 presidential or congressional elections. And then this is a dispute that we're working on right now, as Dr. Evans pointed out, SB 971, HB 1079. The League of Women Voters also is working on this dispute. I'm working on the case, the Tennessee NAACP versus Hargett, one of 2 cases challenging this new voter law that's been introduced in Tennessee that would place restrictions on people registering to vote. And in a nutshell, it's problematic, at least from my perspective. It creates Class A misdemeanors if groups intentionally pay workers based on quotas. It creates Class A misdemeanors if groups register 100 or more people and don't complete state training. And a Class A misdemeanor typically is $2,500 fine or 11.5 months in jail, if enforced. And it can fine groups that submit 100 or more incomplete voter registration forms in a year that lack a name, address, date of birth, and other kinds of provisions. What I don't like about it also is it forces groups to issue a public communication disclaimer. If you're offering election assistance or voter registration assistance, you're supposed to say that my assistance is not authorized by the Secretary of State. You're supposed to say that publicly. And what it also does, in particular for those people who are working on voter registration drives, now you're working on voter registration drives through texting. So you're somehow supposed to integrate that into a texting system in which there's a character limit, so that can be problematic. And the Tennessee NAACP versus Hargett, along with the League of Women Voters and the ACLU, are challenging these laws, are challenging this law in court right now. So where do we go from here? I'm going to scan through a list of strategies that voting rights groups have used in order to advance voting rights across the country. Some groups are establishing grassroots-oriented election protection systems. We did this here in Tennessee. I worked on this in 2016. We identified priority counties in Tennessee, 20 or 30 counties that we would monitor. We worked with the Lawyers Committee for Civil Rights and the Proskauer Law Firm out of New York, and we dealt with more problematic investigations or calls around irregularities. And in many cases, there's not like explicit voter intimidation or discrimination as we know it. In a lot of cases, there's irregularities, there's breakdowns in machines. This is a real ticket. This is a real output of a 2016 set of complaints that came in that we managed here in Tennessee. You can see someone here was purged from the voter rolls right here. You had some machines that weren't working, they were name switching from one candidate to the other. I took a phone call like that myself personally, working on this. You see some issues with ID. There was an incident at Bethel Church here in Memphis, Tennessee, I think an intimidation issue, and there are some other issues. So this is just one example out of many irregularities or issues or inconsistencies that occurred around election protection that we worked on here in Tennessee. Protests do matter for a lot of different reasons. This group right here, the National Student Organizing Committee, challenged the photo ID law in 2012 or 2013. This right here is the Moral Monday movement in North Carolina, which challenged some of the voting rights laws in North Carolina. And probably, if not for their movements, the NAACP versus McCrory case, which overturned one of the most severe restrictions on the voting rights in North Carolina, would not have taken place. But what protests can do is they can interfere with disenfranchisement policies. They can be used to educate the public. They can bring more media scrutiny to voting restrictions. They can provide a moral and political foundation for lawsuits, recruit new activists, and do a number of things other than just stopping a law from being implemented. Some groups develop what I call parallel institutional strategies. That is that they develop institutions or organizations or infrastructures that mimic or mock or at least try to replicate what the established institutions and infrastructures do. It's an old strategy that came out of the civil rights movement and even before that period of time. So there's some examples of groups organizing mock elections. The Southern Negro Youth Congress in the 1930s and 1940s organized a mock election of black voters who could not vote. But what it did was it displayed to the larger public that if given the right to vote, people will take advantage of it. They want democracy. When it comes to redistricting and voting rights, which is a whole nother kind of issue, some groups are putting together community-based redistricting plans that they're submitting to the authorizing body, like the legislature, as a way to demonstrate the community's willingness to engage in political activism. And then it's important to always remember to build out intersectional allies. And by intersectional allies, what I mean by this is voting rights activists have to link their organizing work to a cross-section of issues. In this case, Norris Henderson from Louisiana, he was wrongfully convicted and in prison for 27 years in Angola. While in Angola, he actually organized with other prisoners an electoral organizing strategy in which he identified all those prisoners, where they came from, how many visitors they got, how many phone calls they made, and built out an electoral map in which they could mobilize their family and friends who were outside of prison around criminal justice reform. Since he's gotten out of prison, he's organized electoral organizing initiatives around ban the box and also around jury justice in the jury system. So they're linking voter participation and voting rights with other issues that intersect or overlap with voting rights. Turkish Votes is doing some of the more transformative work here in Tennessee in which they're linking immigration with voter participation and voting rights. So building out intersectional allies is significantly important. Developing community legal coalitions. I stated earlier that that law that was passed a few months ago in Tennessee that has seen 2 court challenges. Some good news came out today. The courts came in today and expressed serious concern with that law that was passed. This is a slide I put together right before I came over here because the court just released this. They did not yet place an injunction on it, I believe, not yet. But the judge did say, wait a minute, this law is going too far. We have to take another look at it. So building out community legal coalitions, that is not just relying upon lawyers and attorneys to kind of helicopter in and shape voting rights suits by themselves, but teaming up with community people and shaping it as a co-production process. So ultimately what I'd like to argue in conclusion is that I think what voter justice does is that it tries to argue that everybody matters politically, not just those individuals who are eligible to vote, but if we really want to build out a larger 21st century voting rights movement, a voter justice movement, a voter suffrage movement, we have to find a way to organize eligible voters. We have to find a way to organize also ineligible voters, youth, new Americans, formerly incarcerated persons, women, poor people, working class folks who are often excluded from the political process. And if we look back to that 15th Amendment story, the 15th Amendment story involved everyone, not just so-called eligible people, but also people who may have been eligible but want to take part in the political process. This last story I'll leave you with right here, I'm on the left-hand side working on the Ban the Box initiative, an initiative that would essentially allow people who are formerly incarcerated to get access to employment opportunities. We worked on a referendum campaign in Nashville, and one of the housing developments that I knocked on doors with, I came across a person who spent about 4 years in prison and wanted to vote in 2008 because he was an Obama supporter, but he couldn't vote because he's in prison. So what he and his friends did was to organize a mock election in the prison. So when he got out of prison in this housing project, he could not vote. But for darn sure, what he did to his neighbors is say, you better get out there and vote. That is that even though he couldn't vote himself, he became a resource for activating others around the voting rights process. And so in a nutshell, what I like to argue is that suffrage and voting rights in the 21st century and today is just as important as it is or as it was in the 19th century. And if we want to really expand the right to vote, we have to find a way to get everyone involved in the process. So I'll stop there.
Questions for Dr. Franklin?
Are there some organizations that you would recommend partnering with as a student?
Well, yeah, absolutely. I'm not sure if the Andrew Goodman Foundation has a formal organization.
They do, not here on this campus.
Not here on this
We'd
campus.
like for them to be here, but not on this campus.
Yeah, but I mean, there's a number of groups. There's the NAACP, there's the League of Women Voters. You can start your own organization, quite frankly, to help educate folks around voting rights. And so, yeah, there's a number of organizations that are out there to work on voting rights. Yeah, absolutely.
And on this campus, we have the American Democracy
The American Democracy Project.
MTSU Votes.
Yeah. For whatever reason, I thought the Goodman Foundation was hooked into the American Democracy Project.
We'd like them to be.
Okay.
Anybody else?
I have a question. What's the American here in the UK? What is our participation rate compared to other countries around the world? You have a general idea.
Western industrialized countries. Anecdotally, like I haven't seen like concrete data. Anecdotally, the argument is that our participation rate is lower, but we have to be careful about that because some Western industrialized countries, Western democracies, have compulsory voting. Yeah, where they mandate that you have to vote. And then there's a lot of things that go into voting that actually allow for higher levels of increase. We are saturated with elections. Sometimes if you're saturated with so many elections, that can sometimes downsize the vote. And then there are other things such as the data points that the data points that have been used are questionable. So for example, do other countries account for formerly incarcerated persons, undocumented persons in the way that they calculate voter participation? So how we look at the data matters in terms of measuring our participation versus other Western industrialized countries. Having said all that, in the United States, when it comes to voter participation, we must be better. We have to be better. We're not good enough in terms of voter turnout.
There was a question right here.
Is there a way, so like for the photo IDs, is there a way to like waive the fee to get photo IDs for people who are in lower income situations? Is there a way to waive the fees for them to get their IDs? Or for groups to raise the money to help them get their IDs?
Yeah, I mean, so your example would be, let's say for example, someone does not have a photo ID or a driver's license. And in order to vote, they go get a photo ID or driver's license. And then, for example, that costs money. There have been around the country some entry points around, does that represent an unofficial poll tax? But that has not been affirmed by the courts. I don't know of any example of groups raising the money to help people pay for the photo IDs, but it doesn't mean it can't be done, because in the 1920s and 1930s, a lot of groups were raising money to pay for the poll tax, which is how they were able to survive it. So, does that answer your question at all? Yeah.
Would you say for people who are able to vote, is their only option to just promote voting, or are there other things that can be done?
In terms of their participation? No. Voting is one aspect of participation. There's lobbying, there's grassroots organizing, there's visiting the legislature, there's working on voting rights cases, there's working on voting rights. My argument is that we make a mistake when it comes to basic voter education, empowerment, turnout campaigns, GOTV campaigns, that we separate out those campaigns from the larger tree of voter justice, that those campaigns have to be linked to all the above that I described, but also to voting rights concerns as well. So if you're working on voter turnout, or if you're just voting, it's important to link those issues to a broad set of issues, whether it be lobbying, voting rights, education, those kinds of things. But there's a lot of ways to get involved, including here on campus. By the way, in which Murfreesboro is an important political site for the Tennessee State Legislature.
Are there any other hands up? Let's go have some ice cream.